Good morning, everybody. My name is Brianna Williams, and I am the Equal Justice Works Disaster Resilience Program Fellow for Community Legal Services of Mid-Florida. Let me go ahead and put my video back on. I am here today to host this wonderful training entitled Evaluating Title to Protect Homeownership Rights. Our speakers today are Rachel Rall and LaTonya Lipscomb Smith, and I'll give you more details about them in a second. I'm really excited that you all are here. I'm really excited for this presentation. I'm ready to learn a lot from our speakers. Before we get started, I wanted to make a couple announcements about our pro bono department and about a couple of activities that CLSMF has coming up. First, our pro bono department would like us to let you know that we are always taking new pro bono attorneys, and I have placed in the chat the contact information for one of our pro bono staff attorneys or pro bono coordinators, and her name is Japonica Jackson. And if you would like to sign up to take cases, take referrals, to attend our pro bono events, please contact Japonica, and her email is placed in the chat. I also wanted to let you all know that we are having or hosting our annual pro bono walk-in virtual clinic, right? Japonica, am I getting that correct? Yes. And that is next week on October 27th, I believe from 3 p.m. to 7 p.m. So if you would like to participate in that and provide advice to clients in the areas of sealing and expunging, family law, bankruptcy, landlord-tenant, and guardian advocacy, please check out the link that is posted in the chat, and that's titled Pro Bono Annual Walk-in Clinic. And we did have a virtual title clearing clinic that was scheduled for tomorrow. That is going to be canceled due to low interest in that clinic. However, if you would like to participate or if you would like to take referrals in the area of title clearing and helping clients with that, and you want to just get some pro bono hours under your belt, again, please contact Japonica because she can point you in the direction of opportunities where you can provide those types of services to our clients. So never fear, there's always an opportunity to serve. And then finally, if you are not a pro bono attorney or an attorney at all, and you happen to stumble upon this presentation, understand that this information provided in this presentation should be considered legal information, not legal advice. If you want advice on how the law applies to your specific circumstances, it is important that you speak with an attorney. If you are located within CLSMF's 12 county service area, our helpline number is that first number posted on the slide. If you are within Three Rivers Legal Services service area, their helpline is the second number posted on that slide. Please contact either of those entities if you need legal advice and legal assistance. All right. And then finally, of course, if you have any questions that pop up throughout the presentation, we will have time at the end to answer those questions. We know that this topic is complex, and this is kind of like a basic level primer on the subject. So we anticipate a lot of questions, and so we have scheduled plenty of time for question and answer at the end. So please post your questions in the chat, and we will get to those as soon as possible at the end of the presentation. Excuse me. Okay, and then finally, the CLE code will be posted in the chat at the end of the presentation. And then after this presentation, an email will be sent out to all the participants with that CLE code, and as well as information on where the recording for this presentation will be posted. All right, so with all of those introductions out of the way, or I'm sorry, all of those announcements out of the way, I now want to get into introducing our esteemed speakers today. So first we'll start with Ms. Rachel Rall. Ms. Rall is an associate managing attorney for Jacksonville office of Three Rivers Legal Services. She has been with Three Rivers Legal Services since March of 2019. Her work in the area of securing heirs property through probate process and estate planning is funded through the Home Sweet Home grant from the Florida Bar Foundation and a grant from the Local Initiative Support Corporation. Prior to her employment with Three Rivers Legal Services, Ms. Rall was a solo practitioner concentrating in the areas of family law, probate, estate planning, and real estate. Ms. Rall has been licensed to practice in the state of Florida for over 18 years. She is a member of the Jacksonville Bar Association, the Jacksonville Women's Lawyers Association, and the president of the Catholic Lawyers Guild. Thank you so much, Rachel, for working with me on this presentation and for joining us today.
Thank you.
Next, of course, thank you so much. Next, we have LaTonya Lipscomb Smith. LaTonya is a staff attorney with Three Rivers Legal Services. She works exclusively on the heirs property program. The main components of the program are education and community outreach, estate planning, and probate litigation. The goal of the program is to preserve, secure homes for at-risk homeowners by helping them get clear ownership of their homes or create and plan a transfer of ownership for in the future. Excuse me. Sorry, I have a little bit of a head cold going on. Prior to joining Three Rivers Legal Services, she was the owner and sole practitioner of Lipscomb Smith Law, serving clients in the areas of probate and estates, family law, and criminal law. She's licensed in both Florida and Georgia. She has been honored with the Outstanding Pro Bono Service Award for pro bono work by Jacksonville Area Legal Aid. And her favorite hobby is traveling. Any opportunity to pack her luggage and stamp her passport is a fun time, and that sounds like a fun time to me as well. Thank you so much, LaTonya, for being here, and we are so excited for both of you to share your knowledge with us today. So with all of those announcements and introductions, I'll go ahead and turn it over, to our esteemed speakers. And luckily, this is now when I'm losing my voice. Thank you so much, and I'll pass it over to you.
Thank you, Brianna. I appreciate that.
And I should say, do you want me to take over the poll, or do you want to run the poll? Okay, so I'll go ahead and run the first poll. We just wanted to get an idea of who we have in our audience. And so let me start that poll. And so I'll give you all a minute to let us know the level of experience that you're bringing to us this morning. So just, choose the best answer. The first one is I have no familiarity with the subject. The second one is I have some familiarity with the subject, but I've never worked with the subject before. The third one is I have worked sparingly with the subject, but would like to know more. And then finally, I am comfortable with the subject matter. I'll give you all about 30 more seconds to enter those answers. Looks like we've got 31 of 41 folks answering the question so far. All right, a couple more folks. All righty. All right, so I'll go ahead and end the poll there. All right, can our speakers see the results?
Yes.
Yes, thank you. That helps us a lot in our presentation.
Perfect.
Yeah. Okay.
Looks like we've got a lot of folks that are new to the subject area in the audience. I'm glad for that because I am too. So let's learn together.
Thank you, Brianna. I'll take it from here. So why is this important in terms of clearing title and learning about the probate process? First and foremost, you want to have your ownership rights in full effect. You want to be able to sell, transfer, and take out a loan. Oftentimes we have clients that come to us that are in a bind because they are unable to do those things. And so you have to have clear title to sell, transfer, or take out a loan. In Florida, we are a hot button area in terms of disaster relief. If you have hurricane damage, roof damage to your property, in order for you to get insurance proceeds or FEMA relief, you have to prove ownership in order to get those benefits. Next slide. Thank you. So when you are thinking about the subject of clearing title, first you have to know about the document that you're trying to clear. And so the document that you're trying to clear or even research are deeds. And so in Florida, we have 5 popular types of deeds that you can look at. We have the warranty deed, which is the most protected deed. And if you have a choice in the matter, you always want to try to strive to have a warranty deed when you're dealing with property. Quit claim, that is more of a, that is not protected, and that's usually person to person. We have quit claim with life estate. We have what's called the Ladybird deed, which is the enhanced life estate quit claim, and then the agreement for deed. But starting off, we'll discuss the warranty deed. Next slide. So hopefully you can see a clear picture of the warranty deed. But this particular deed, it conveys fee simple of property from seller to buyer. With a warranty deed, it has covenants of title. And what this means is that these are promises or guarantees that the seller makes that are enforceable in court by the buyer against the seller. So if there is a covenant that is found to be untrue or that is broken, the buyer then through court can obtain a judgment against the seller for any damages that the buyer incurred as a result of that untruth. And so with the warranty deed, when you're dealing with your dream home or your home where you're paying hundreds of thousands of dollars, you will oftentimes find when you're doing a title search that it is a warranty deed. And with a warranty deed, we have 5 covenants or promises, guarantees that the seller is conveying to the buyer. The first covenant is the covenant of cession, and this means that the seller is purporting to be the true owner and is the only party in possession of the property. Secondly, we have the covenant of the right to convey, and this says that the seller does in fact have the right to convey this particular property and that it doesn't belong to anyone else. Covenant against encumbrances. This is where the seller asserts that there aren't any undisclosed or non-visible encumbrances against the property, meaning liens or anything like that. You have to be able to convey that. Fourthly, covenants of quiet enjoyment. This says that the seller states that the buyer's use, possession, and enjoyment of the property will not be disturbed by any third party asserting rights to the property. So the buyer can rest assured that no one else is going to come and try to stake claim to the property that they just purchased. And then lastly, there's the covenant of general warranty. This is where the seller will protect the buyer from harm caused by title defects and defend a buyer from any claims by others to the property title. So the long short of it is the warranty deed, it's very important. It's the most protected deed that you would want to have. And so in our office, when we draft deeds, we are never drafting warranty deeds. We draft various types of quitclaim deeds. And it's for that particular reason, is because it has all of these covenants that you are purporting to have. The next deed is quitclaim. Next slide. The special language and each deed that you'll notice in the presentation, the highlighted portions are the special language that makes the deed that particular type of deed. So for example, here with the quitclaim deed, you'll see the language where it says aliens, remisses, releases, and quitclaim. So it's very important that if you are drafting or if you're looking at a quitclaim deed, that it actually has the language that it is a quitclaim. So what is that? This is a deed that has no covenants to the title. So none of those promises that we just discussed for the warranty deed. It simply transfers property by a person who has or might have a claim to some interest in the property. So in other words, there's no guarantee that you actually have an interest. It's just if a parent wants to deed their property to their child, they're saying through a quitclaim deed that this property that I have, or I believe that I have, I'm going to quitclaim that interest to my child. Next slide is the quitclaim deed with a life estate. The special language here that you want to look for in a quitclaim life estate deed is acknowledged, where the seller is acknowledging, has granted, bargained, and does quitclaim to the grantee or grantee's heirs, and assigns forever and reserving unto himself or herself a life estate. So what does this mean? This entitles the holder the right to possess, live at, or use the property for the duration of their lifetime. And so upon the death of the grantor, the ownership passes to the remaindermen, who now own the property in fee simple. So in other words, that means that if a parent is trying to deed a property to their child, but they still want to live in the home, possess the home, and use the home as their own for the duration of their life, they can do that. But upon death, by operation of law, then their child, who's considered the remainderman, will then receive the remainder of that interest at the time of their death. The next deed is the quitclaim with enhanced life estate. So this I call the, you may hear this referred to as the ladybird deed. There is a myth or phantom that this deed has some origins in dealing with Lady Bird Johnson and President Johnson, and that he had deeded his interest to his wife upon his death, but he still wanted the ability to own the property as if he owned it in fee simple. So what this deed allows is that it allows the grantor to still maintain ownership and the ability as the sole owner of the property only, and upon the death of that grantor, only if the property still exists does the remainderman then take the property. So the difference between a quitclaim deed with a life estate versus a quitclaim deed with an enhanced life estate is that when you only have a life estate, the grantor does not have the right to deed the property to someone else, to sell the property to someone else without the consent of the remainderman. So they are kind of locked and limited. Another way to look at it is that they are a life tenant in the property. However, when you look at a quitclaim deed with an enhanced life estate, the grantor is treated as if they are the sole owner and they just happen to have remaindermen, which means that with an enhanced life estate or a ladybird deed, then the grantor will be able to mortgage, they'll be able to sell the property without the consent of the remaindermen. And only if the property is still in existence at the time of death of the grantor, then the remainderman will then receive the life estate. So personally, and with us at Three Rivers, we really do enjoy the ladybird deed a lot because it still allows our clients to be able to have autonomy, to be able to act as if they're the sole owner without the limitations of the life estate. So I think it's just a great document. And then lastly, we have the agreement for deed. Next slide. Thank you. This may be a little bit harder to read, but basically the agreement for deed is an agreement between the buyer and seller, allowing the buyer to take possession of the property before the full purchase price is paid to the seller. And within the language of an agreement of deed, you will have the fact that that the seller is selling the property for a particular price, and that the seller is agreeing, and that the seller is agreeing that the buyer will pay, for example, $400 every month for the next 20 years, And then upon the full purchase of the price, then the deed will fully transfer. And so in the agreement for deed, you will also have language in there stating not only the terms of the contract, but also that it is a mutually agreed upon transaction between the buyer and the seller. Next slide. So when you are talking about, we've discussed about deeds and what documents you're actually looking at when you are clearing title. Then you want to know about the relationship of the ownership when you're looking at the deed. And another way to say that is, how is title taken? So there are 5 common ways that title can be taken. And the first one is fee simple. Fee simple is where the grantee owns the property completely without any limitations or conditions. So when you are looking at the deed, you will see where the language will say from grantor to John Doe, or from grantor to John Doe and their heirs, and that's it. When you see language like that, then that means that it is fee simple, it is absolute. The next type of title that you will see when you're looking at language in the deed would be tenants by the entirety. In other words, this is between married couples alone. So this is jointly owned marital property with rights of survivorship. And what happens is that when one spouse dies, the surviving spouse takes title automatically without having to go through probate. So the special language that you will see in your deed when you're talking about tenants by the entirety is when you will see from grantor to John and Jane Doe as husband and wife. And let me take this opportunity to make a caveat. Unfortunately, we have been seeing in deeds where in mortgage transactions, they are not including, even though a person may be married and the deed may say John Doe, a married person, they will only name one spouse. And you do not want that. If a person is already married, you want both of their names on the deed, and you want them to be labeled as husband and wife. When that does not happen, and the listed spouse that is labeled as married dies, it just opens up a whole myriad of probate problems further down the road. And we can get to that later when we go through probate. But for tenants by the entirety, it's a married couple, and you want them, John and Jane Doe, to be named as husband and wife. Next is tenants in common. Tenants in common is really considered as the default type of ownership when you have 2 or more owners of the same property. Tenants in common also runs amok when you're dealing with heirs property. And this is where you will have no special survivorship language that's listed. When you have 2 or more people that own the property as tenants in common, you may see language such as several people's names listed, and then that's it. Each owner, let's say you have 3 names listed, each owner each have the right to access the property. That can become cumbersome depending on who's living there and what you're doing with the property. And then any income that is drawn from the property, each owner is entitled to that percentage of income depending upon the amount of their ownership shares. And then you have joint tenants with right of survivorship. This is, think of this as tenants by the entirety, but without being married. So this is where you may have, you may see language that says to John and to Joe with rights of survivorship. And what this means, similar to tenants by the entirety, is that upon the death of one person, the surviving person will take the whole as 100% by operation of law. And by operation of law, that means that you do not have to go through the probate process and that it happens automatically. So this is a great estate planning tool if you're drafting deeds or looking at deeds where you want to see language as husband and wife with rights of survivorship, because you know that title automatically passes without having to go through probate, which is can be a great thing. And then lastly, you have remainder interest. Remainder interest really just occurs when you're dealing with life estate and enhanced life estate. And this really means the future interest, the people that own the property in the future, which doesn't take effect until the grantor or the person with the life estate actually passes away. And I will pause and hand it over to Rachel.
Thank you. Okay, next slide.
Oh, excuse me. I have
one more slide.
So
go ahead.
very briefly, this chart is just a great visual if you're looking at these slides in the future. When you're dealing with multiple grantees and you want to know which types of title ownership can you avoid probate. You could, as I mentioned, tenants by the entirety, right of survivorship. Which types of ownerships can you be protected against creditors? The only one is tenants by the entireties. And then for the first column, who is it available to? The only one that you have to be careful about when you're looking at it is tenants by the entirety, which is exclusively for married couples. So if you are doing a title search and you see two folks and they are listed as husband and wife and they aren't actually husband and wife, then you will be running into a problem. But this is a great reference point for the future. Thank you, Rachel.
Okay, next slide. All right, so we're going to talk about a title search. Next slide. So why do we care? Well, LaTonya's told you all the ins and outs of the different types of deeds and some of the problems that can happen. But before we know that, we have to search the title. We want to know if our decedent had good title when they passed. We want to make sure we don't make it worse as we're doing the probate. Like doctors do no harm. We don't want to do any harm because the clients could come back at us if we've done something wrong and they don't inherit good title. And we need to know whose estate we're probating. Sometimes it's not so clear. Next slide. So let's talk about how we do a title search. The first way you can do a title search is hire a title company to do that. That is expensive. So when we're dealing, as we are with legal aid and same as Clismouth, it's easier for us to do our own title searches. Sometimes we may have to turn to a title company, and they are usually used when you're getting a mortgage. They will do a title search. However, I will put a caveat. Do not trust that if there's a mortgage on the property, that the mortgage company did their their title company did their due diligence. And I'll kind of explain that later. So what we do is, first of all, go to the property appraiser's website. You can, in most counties, type in the address, which is usually the easiest way to do it because you're not sure whose name the property is under. I will say that in researching for this presentation, I looked at Orange County because that's where Clismouth is. You're going to go to the comptroller's website, not the property appraiser's website. After that, the search, the materials that you will get will be similar. It's just you will go to the comptrollers. Other counties, you will go to your property appraisers and find the property. So what can we find once we find this information? If you go to the next slide, I think. Yes, so here is from Orange County Comptrollers. You can put in, and I know this is kind of small, I picked a random name. I picked out Donald Jones, found this property. Next slide. Okay, So here's how it comes up with the comptroller's search. You get all these property addresses. When you click on these, you're going to find all sorts of information. And I did not want to divulge any personal information from some stranger. So things that you will find on your search, you're going to find in most counties a picture of the property. So you can find out if you are actually looking at the right piece of property. You're going to find out if the property is getting the homestead exemption. This is our ultimate goal when we are probating, is making sure that our clients are receiving the homestead exemption on that property that is allowed in all counties. So there'll be a line that says whether or not they're getting it. How the property is titled. Hopefully it will say something like heirs of or the estate of. It may list several people that are already on the deed. That helps you later on when you're trying to find the actual deeds to the property. You will have a link, in most counties, will have a link to the public records. So you don't have to go to the public records and trying to find the deeds. There'll actually be a link on the property appraiser's website. And if you go to the next slide, okay, so I know this is difficult, but right in the middle where you see a lot where it says sale date, book and page, these are actually links. And this is from the Bradford County. And again, every single county lays out their search page is different. But here, these are actual links where you can go and click on these to get the deeds. That's going to help when we need to look at multiple deeds. But again, you can see the picture here of the property. This one's actually a bird's eye view. It will tell you, it has a link to the tax collector's office. One of the very important things is it tells you or gives you an idea whether this property sits inside or outside the municipality. And again, we're going to talk about that in the probate section, but it's very important you know whether this property is inside or outside of the municipality. It will tell you most of the time the acreage. Going back to your law school, if you remember, you can probate or you can homestead 1/2 acre of land inside a municipality. Outside the municipality, it's up to 165 acres. So if you have, over an acre, you're good. There are municipalities where you have an acre of land or 3/4 of an acre, but you can only homestead 1/2. So that gets to be a little sticky when you're trying to write orders for the courts on the homestead orders. You'll also get an idea of the just value of the property. I call that for the curious to see what your clients, what the home is worth. Understand the just value, at least like where we are in Duval County, it's an estimate by the property appraiser's office. That is not necessarily the actual value. You may need to get an appraisal by a reputable appraisal company to get the actual value. That's really only needed if you have heirs who want a buyout. And we'll talk about that in probate in just a minute. So once you've come up with this and you have got a link to your the very last deed, which is the deed that your client is looking at, you'll go to the public records. If for some reason your link on your property appraiser's website is not working, it could be either the county doesn't have that connection or it's an older deed. For instance, in Duval County, you can only research back to 1988. After that, you have to walk down to the courthouse, to the public records, and do some searches for those deeds. Other counties do go back further. And there are a few counties that don't have this link at all. So you could go to my county, my Florida county, and do a similar search. Otherwise, go to the public records. You have names, you put that into your search just like that comptrollers, and you can look and find your deed. Why is this important? Again, LaTonya talked about the different ways that people take title to the property. We find a lot of people like to write their own deeds. And for example, when you have husband and wife, you're wanting that to be by the entireties so that on the second person to die, that's the person we have to probate. If dad just died and it's husband and wife, we don't have to worry about that as long as mom's alive. We simply file the death certificate of dad in the public records, and mom has that property. It's on that second person to die that we have to. Now, as LaTonya said, if it's not delineated as husband and wife, it's just Jane Doe and John Doe, then each of them on their deaths, each of them own a 1/2 interest in the property. So if both of them passed away and the son has come to us and said, mom said, I get the property, we now have to probate both estates. I have a case recently where both parents died. The son decided he was the sole heir, and he recorded a deed from mom and dad deceased to son as sole heir and gave it to himself. Well, that's a title problem because you can't just give yourself property. Mom and dad, or mom or dad, had to sign that deed. So we have to probate grandma's estate. And I'll explain a little later how complicated that one got. So you need to determine who has the property. Once you get your deed, you want to make sure how title is taken. You want to make sure you have the proper description, legal description on the property. A lot of times the clients will try to write their own deeds, and they will take the parcel ID and they'll just put that on there. And that doesn't tell anything to anybody. You want to make sure the person who, the grantor or the grantors, signed the deed, that there are witnesses, and it was notarized. Sometimes we find there's a witness missing. Usually the clerks will catch if there's not a notary, but they won't necessarily catch if there's not a good witness. Some clerks in the county, in the official records, they'll record anything. Other clerks will tell you you can't record something, and unless you push them, they're not going to record it. So we see a lot of funky things that are recorded. So make sure all of those points are taken care of. So you get your deed, you look at it, you see who we have to, whose estate we have to probate. All right, next slide. Okay, we've gone through this. Determine how the client's parents took title. You want to make sure it's a right of survivorship. If it's one person giving the property on a right of survivorship, is the one of the other survivors deceased, or are there two people? You have to look at how many people there are. As LaTonya said, if there's 3 people, you're only probating 1/3 of the estate. What happened to the other 2? Are there other deeds maybe you need to look at under different names to make sure that title is good? What you're looking for is what we call the chain of title. We're starting with the most recent, we're going backwards and backwards and backwards and backwards, and making sure each and every step that title was brought forward correctly by the person from grantor to grantee, and then that grantee is a grantor to the grantee on down to make sure everything is correct. Okay, next slide. Okay, probate. So next slide, let's go on to probate. Probate is very forms driven. So what is probate? It's a legal process in which the assets of the deceased person are collected and inventoried, then distributed to pay creditors' claims against the estate. If there are any remaining assets, they are then distributed to the heirs or the beneficiaries of the person who passed away. The court determines the validity of a will and oversees the process to make sure the estate is properly administered. This is a great statement. I believe LaTonya found this on the Duval County Court's website. So we have precise statement. Next slide, please. Okay. Two useful tools for probate are the Florida Rules of Probate. That is in the civil procedures. It's chapter 5. It tells you everything you need about probate, the general rules, the rules of procedure governing probate. The only thing it doesn't do is other areas of law, they have no forms. You have to buy the forms from the Florida Lawyers Support Service, Inc., fondly called FLOSSI. They do charge a fee. I think it was about $125, but you get a huge amount of forms and for different situations, for testate, for intestate, for if you have a spouse, if you have heirs without a spouse, and it's a great tool. Now, I know that we have judges here in our county that will say, great, love the forms, but you're an attorney, you can draft. So be very careful. Some things are great to use the forms. Others, you may have to manipulate them a little bit to fit your situation. The others, the rules are the how, the why, and the law is the Florida Probate Code. That is Florida Statute 731 through 735. Lots and lots and lots of information in there. The one we usually look at all the time is 732, the intestate succession. There are all, and I'm not going to go into a great big huge details of all the intricacies about testate, intestate, who gets, who doesn't, except with the how it applies to the homestead, because it is very different. Next slide. Okay, we have formal administration and summary administration. I'm going to go through the formal probate, or the formal administration or full administration, we sometimes call it. LaTonya will pick up on the summary administration. We don't have a lot of time, so I will try to do this quickly, but remember you have the rules and the laws. Next slide. Okay, so full administration, you are opening the estate with a petition for administration. This is either with or without a will. If your client's decedent has a will, it's called testate. If there is no will, it is intestate. We really like there to be a will, because if the will will tell us, hopefully if it's properly written, will tell us who is going to get the decedent's property. And those are called beneficiaries. If it's an intestate, they are heirs. In formal administration, we have a personal representative appointed. That person steps into the shoes of the decedent to finish up their earthly financial matters. We need the will, the original will, and a death certificate. The original will by law is supposed to be deposited with the clerk of court in probate division within 10 days of the decedent's death. That never, ever, rarely happens. Occasionally, but rarely happens. The purpose of that is to preserve that will, to make sure nobody else comes up with some other will or that will is destroyed. The court appoints that personal representative. They are nominated by the will, and the court will appoint them, or they are nominated by the majority of the heirs. In order to be a personal representative, you can be a family member who lives anywhere, or a non-family member has to be a resident of the state of Florida when they are nominated and throughout the proceedings. If for some reason they move out of state after they have been appointed as personal representative, they are no longer allowed to be the personal representative. You have to find another one. The personal representative helps the attorneys find the creditors, notify the creditors, if any, And they are given a period of time to come in and make claims against the estate. Florida allows creditors up to 2 years to make claims against the estate. That means a creditor can actually open probate. I had one time a funeral home open probate because they had the body of a decedent and there was nobody to claim them. So that funeral home had to come in, open probate, and try to find an heir. Normally they don't, but it's so in the probate, in full administration, we will allow what we call unknown creditors 90 days from the date that we file or we publish a notice to creditors in a local paper that handles legal notices. Those creditors have 90 days or 3 months to come in and make a claim against the estate. If there are known creditors, like all the bills that the decedent is getting from the doctors and the credit card companies, and maybe an ambulance company, those, the notice to creditors is sent directly to them and they have 30 days to make claims against the estate. So those notices are usually sent by certified mail, so we know when the 30 days start. And it is not uncommon to get those claims a day or 2 or 3 late. So we can send them a notice or object to that claim, send them the notice that says, sorry, you're out of here. Never had anybody, any creditor fight that objection. So the personal representative is also going to help gather all the assets. What's out there? Is there a bank account? Are there cars? What are the titles? A lot of times we see this mobile homes. We deal with a lot of property that have mobile homes and they are not made part of the real estate. So they have their own titles. So if you have a single wide mobile home, it's 1 title. If you have a double wide, it's actually 2 titles. The numbers will be the same, but there'll be an A and a B. And if you have a triple, then it's A, B, and C. So you want to make sure you look at those. We file an inventory with the court so the court knows what assets we are probating. Now, fortunately, in our practice, we are usually dealing with only the homestead because we have low-income families. They just have the home. They don't have credit cards. They may have some debt that we have to deal with. But usually there's not even a bank account. There's not a lot of assets. So when you are putting the home in the inventory, it's exempt. That means Florida Constitution and Florida law protects the homestead from creditors because the whole point is to make sure that families are not left homeless. So going back to one of the statements that LaTonya was making is a lot of times you do see as time has come forward, we don't see it as often, but it used to be, and Florida law used to only protect the homestead if it was in the husband's name because he was the breadwinner. If a woman had a home in her name, it usually was not protected. And ironically, that law wasn't changed until I believe the mid 1980s, where it was whoever owned the home. It's not just the breadwinner, but whoever owned the home, they got the homestead protection. So that's why it's so important to know who's on that deed. Again, with the right or survivorship, it may be only one of those who is actually living in the home. The other 2 may be siblings, and it's an estate tool to make sure the home stays within the family members. So after we have all of our assets gathered, we have to file what's called a petition to determine homestead status of real property. This is the one thing that is so important that helps us make sure that the home stays in the family. We have to list everybody that, let's say it's an intestate, we list everyone who has a right to that home. So one of the things we found recently, we are having our clients do a family tree, especially when you have children who have passed away, who have children, because the rule for inheriting the homestead outside of a will, because the will hopefully tells us who's going to inherit, but an intestate, it's to those lineal descendants in being at the time of the death of the decedent. So if the decedent had 3 children who predeceased them and they have children, those children are the ones who will inherit their parents' share. And it's called per stirpes. That's, again, go back to your law school. Per stirpes means per line of succession. So if one of the children had 2 kids and one has 3 and one has 1, each one, depending on how many children altogether there were, each of those lines shares that parent, that deceased parent's share. So more and more the courts are looking at these affidavit of heirs. So we just give a family tree and say, fill out the family tree so we can figure out who's who. Once we have that, put all that information in the petition to determine homestead status, the courts will not look at that petition until that 90-day creditors period has expired. Once it has, the court will hear that petition. Now, one of the things that we try to do, because the goal is for our client to have 100% ownership of the home because they are living there, they may be paying the mortgage, they may need repairs, they may need a ship loan, they want the homestead exemption. So we try to get all the heirs to agree and we send them a consent. So it's a waiver and consent. I understand I have X amount interest. I'm willing to give, I want the court to give my share to my sister or my brother, whoever the petitioner is. One thing that you do not want to do, and you may have heard this term, is disclaim. They are not disclaiming their interest. They are consenting to the court giving them the interest. Disclaim means you want the court to treat you as having predeceased the decedent. So that goes back. So if you have kids and you disclaim, then your kids are going to get your share. And that's not the goal. So be very careful with disclaimer language. The other thing there is an exempt property, a petition for exempt property. This is usually the car, the motor vehicle. Florida allows 2 personal vehicles to be exempt from creditors. Now, this isn't the collector car. This isn't, the other thing is furniture and furnishings under $1,000. So if those furnishings are antiques, that is not under the exempt property. Unlike the petition to determine homestead, the petition to exempt property must be filed within 4 months of the appointment of the personal representative. And it lists all those exempt properties because, again, it's easy to get rid of those things. Suddenly a car isn't there, or somebody's cleared out the personal effects of the decedent because, you know, mom died, we got to clean out her house, and suddenly stuff disappears. So this has to be done within 4 months. Court, unless somebody argues about it, courts may be lenient about that 4 months. It depends on what it is and what we're talking about. So we've already got our homestead status taken care of. We do or don't have the exempt property. We can now start winding up the decedent's affairs. So let's say we've got our order of determining homestead. We've distributed the property through that court order, but we have creditors. The creditors get sent a copy of that order determining homestead. They will get a copy. They will have already gotten a copy of the inventory. And if the only asset was the homestead, we ask them to waive their claim because they're not going to get any money out of it. Sometimes they do waive claims, sometimes they don't. When we are all ready to take care of and discharge our personal representative, we file a petition for discharge. We send a consent again to everybody, say, hey, consent to the petition for discharge. Your creditors often will ignore all of those, so you will have to set a hearing on that petition for discharge. If everybody's agreed to everything, you can, in most counties, just send an order to the judge. and the judge will enter an order without hearings. That's the beauty of probate. And especially in today's world with Zoom. Most counties are still doing probate by Zoom. They're going to stay that way. I know we have one county, the judge says, I'm tired of Zoom, come see me, even though it's a 5-minute hearing and nobody else is going to show up. We have to come to the court. So that is full administration. The next slide, if you go to the next slide, is just closing your estate. So most likely you won't need to do an accounting. If you have a bank account with money in there, it's going to go on the inventory and the creditors are going to see it. So you may have to divvy up some money between the creditors. Of course, there's other steps, but there are certain things that get paid first. There's a hierarchy of creditors, and we don't charge, obviously we don't charge, but your personal representative may have paid a filing fee. They may have paid the funeral expenses. Those are the first two things. In private practice, attorneys get paid first because Florida law requires probate to be done by an attorney. So they make sure we get paid first. So if you're taking care of your creditors, you've distributed assets, and you get your personal representative discharged, you're good to go. And I will let LaTonya take over for summary administration.
Thank you, Rachel. So to wrap everything up with summary administration, this is the shorter probate process than the full administration. Depending upon how quickly you can get your ducks in a row and if the court is working, cooking with fire, cooking with grease, I say, you can get this done in about 3 months, a summary administration. By statute, you can do summary administration if you have at any point in time after the decedent's death, if the estate is $75,000 or less, or if the decedent has been deceased for 2 years or more. We do have certain jurisdictions in our state that if the decedent has been deceased for less than 2 years, you will have to file the notice to creditors and wait that 3-month statutory period that Rachel had mentioned to you all before. And so when you're doing that, it's just worthwhile to go ahead and file for full administration because you are protecting your client in placing them in the capacity of being a personal representative and just going through that whole process. But if you are fortunate to make it to summary, to open up a summary administration, you have to file a petition for summary administration. And if there is a homestead, you also want to file the petition for homestead status at the same time. You can do it all at the same time. For this process, it is important to formally serve, similar to full administration, all of the heirs and beneficiaries that are listed in the will, if you have a will, or through intestate succession. There is no personal representative does not need to be appointed. And we put in here typically. The reason why it's typically is because there's always a caveat. If we oftentimes have clients come to us where their parents or the decedent has been deceased for a very long time, but they need to deal with the mortgage company, and the mortgage company will not talk to them unless they have been appointed as personal representatives. So oftentimes we will file a summary administration, but then ask for our client to be appointed as personal representative for the limited capacity of communicating with the mortgage company, for example. Creditors are usually barred if you file this after the 2-year period. So then that's another benefit of filing for summary. You don't have to worry about the 3-month waiting period and filing that publication with your newspaper. And then no inventory needs to be filed. All the assets that you would list in an inventory in a full administration, you would go ahead and list that in your summary petition. So you have all of these documents, you get them filed, you have formally served all of the beneficiaries of the case, you can set it for hearing, or depending on your jurisdiction, go ahead and send in your proposed orders to the JA. If a hearing is required, the court will let you know. But oftentimes, if everything is straightforward and you have all of your ducks in a row, the judge will just go ahead and sign your order granting summary administration, and your order granting homestead if it is applicable. And then all of your assets are distributed according to the orders. So summary, it's very good. It's very straightforward. A lot more streamlined than full administration. So if we have clients that come to us that are in a bind and on a time restriction for whatever reason, if the decedent has been deceased for more than 2 years, we will more than likely file for summary administration. And so, Brianna, that is the conclusion of our presentation. We have another poll, I know.
Thank you so much for that wonderful information. That was a lot, and I know I'm for sure going to go back and rewatch it because it was just so much information, and I really appreciate it, and I'm sure our participants appreciate it as well. I'm the type of person that always likes to quiz everyone after we are done learning, just to cement what we just learned. So I'm just going to do a couple poll questions just to see if this information really sank into those heads. So if you could, I'm just going to go ahead and launch this poll. And I'm also the type of person that likes to put little jokes in my polls. So that's what you see there. I'm going to go ahead
I
and
like that.
That's a good question.
And give you a couple seconds to answer that question. So it says, where should you start the title search? Should you go to the clerk of court site first? Should you go to the property appraiser site first? Should you go to the DMV site first? Or should you hire Urban Meyer and hope for the best? We'll see about that later in the season. Or I think we probably already know. All right. Give you a couple more seconds. All right. All right, so we've got a smart bunch here. So yes, the answer is to go to the property appraiser site first, or if you're in Orange County, we're going to go to the comptroller site. Is that correct?
That's
Yes.
right. Mm-hmm.
Awesome. And if you answered hire Urban Meyer and hope for the best, I'm really rooting for you. I'm hoping that this is everything that you dreamed of and more. Go ahead and share the results just so everyone else can see it as well.
Wonderful.
All right. And we're going to
And
go.
you can go to the clerk's website if you want to do it the long way around.
All right. And the next question isn't so much a test of your knowledge, but just really to see if you're going to use this knowledge. We certainly hope that you will. We just want to get an idea of if you're willing to use the knowledge that you gained here today to help us at CLSMF or even at Three Rivers Legal Services, if they want to refer anyone to pro bono for these services as well. So I'm going to go ahead and launch this second and final poll. And the question is, after this presentation, are you willing to use the knowledge that you gained to assist clients? The first answer is yes, I would like to volunteer with CLSMF or Three Rivers Legal Services pro bono program. The second answer is yes, but I will use this information in my own practice. The third answer is no, I don't feel comfortable assisting clients yet, but I will, or I potentially feel comfortable in the future. And then the third or the final answer is no, I will not use this information obtained during this presentation. So I'll give you all a couple more seconds to answer that question. Just excuse me.
And I'll let you know, Three Rivers covers 17 counties in North Florida. We cover the 3rd, the 8th, and the 4th Circuit and St. Johns County. So you can always contact either LaTonya or myself if you're interested in taking cases here for Three Rivers.
Awesome. Thank you for that, Rachel. Lots of opportunities to serve.
Yes.
Mhm.
We have cases we can help you with, and we help you, we walk you through everything. So we are your
Mhm.
mentors on this.
That's wonderful to know. All righty, I'm going to go ahead and end the poll and share the results. Looks like we've got a lot of people who plan to use this information to help others. And I really, really
Wonderful.
appreciate that. Like Rachel said, and like I said in the beginning of the presentation, if you're one of those folks who answered the first, or who answered A, reach out to us as soon as possible so we can get you in our programs and refer cases to you as soon as possible. All right. So we are now going to get to the question and answer portion of this. I see lots of information in the chat. Let's see. All right, so I'll start with the chat and then we'll make our way to the Q&A. All right.
Okay.
And so the first question in the chat is, can a grantor convey a life estate to himself and a grandchild for her life without a right to sell or encumber, and then to the remainderman? That you can find that question in the chat. I know you're probably going to need to look at that one.
Okay.
And that the person who posed that question was Patricia Bradford, I believe.
Oh, okay.
Self and a grandchild.
Yeah.
Patricia, if I'm understanding it correctly, you're trying to do a life estate to the person and the grandchild at the same time, for a life without a right to sell, and then to remain. Okay.
Patricia says yes.
Oh, okay. I have not seen that. I personally have never come across a life estate where it's to two individuals at the same time and then to remaindermen. Usually the best practice is that it's to one individual with a life estate. Yes. Yeah. You would want to draft a different type of deed.
And what we do use that, the ladybird, and that's what kind of what you're seeing is the ladybird deed. But we usually use that, maybe the husband and wife, they will keep it and then to the child. Now, what you could do is the grantor could do a ladybird deed, and then the child, the grandchild, being the remainderman. The problem with that is you've got to watch how old is that child and what is the likelihood of the grantor dying before that child, that grandchild reaches majority, because then you're looking at a guardianship issue that you're creating for that child's parents. Because if in that homestead where I was talking about all the heirs and the other children taking a title, if any of those are minors, the court is going to require a guardianship for that child to take its interest. The courts are not going to, they used to, years ago, I didn't have a problem, but recently we used to be able to have the parent consent to that interest going to whoever's trying to get 100% interest. Now they're saying, no, that child may want their money out of it. Now, what you could do once you have the guardianship is ask the court that or tell the court it's in the best interest of the child to sell their interest to whomever. And then you've got, yeah.
The grandchild is an adult.
Is an adult.
Is an adult. So we don't have to worry about that.
I would leave the property, the ladybird deed, to the grandchild. Because remember, you cannot dictate from the grave what you give someone. You can't tell them they can't do something. Once you give that property, and that's really what's going to happen. So you can't tell the grandchild you can't sell the property.
Good question.
Thank you for that, Patricia. And I hope that you got the answers that you needed this morning. It sounds like you did. All right, let's make our way. I don't see any other questions in the, actually, no, there's one other question in the chat. This comes from Caroline Zoes. What happens if the bank account is jointly owned with living individual or with a living individual?
If it's a joint account, the person who's living, when one person dies, that account goes to the other person. It's always when we're doing estate planning, we say, once one person has passed away, you may have everything in joint names, and that's great until you are the remaining person. Now you really have to get a will and make those determinations, or put beneficiaries on all the accounts and everything like that, so that your goal is that you do not have to probate. And that's the purpose of some of these ladybird deeds and quitclaim deeds and things like that, to avoid probate and keep it in the family.
All right, thank you for that, Caroline. I'm going to make my way to the Q&A questions, and then I'll go back to the chat if time permitting, because those questions were put in after these questions, and I want to do a first come first serve kind of deal. So Teresa says, with the ladybird deed, when it is sold by grantor to the new owner, does the new owner own it in fee simple?
Yes.
Yes. Mm-hmm.
All right.
You have now destroyed, once you do that, you have now, because the ladybird deed says, I get to do everything with my property I want to do. And if I own it when I die, then you get it. But if I own it before, then you don't get anything. So that the remainderment's been destroyed.
Yeah. And the remainderment with the ladybird deed, you just don't have it. You had a potential interest. You just don't have it anymore.
And which, again, when you are doing your title search, make sure you look at that deed, because as you saw on that on the life estate, it's a very small couple of words that says life estate. And with a life estate, you can sell your property if you have reserved a life estate, but the interest you have sold was your life. And I've actually had this one happen in a divorce. A husband bought a piece of property, and it was for the life, and the original grantor, the life tenant, had passed away. I said, he doesn't own the property anymore. It now reverts to the remainderment. So you've got to make sure that your client's parents didn't try to sell their life estate, and now they don't own the property. And that does happen.
And this is what happens when you do quitclaim deeds yourself and you're drafting deeds yourself, is that you don't carefully look at the language of the deed. And so I know legal expenses are high, but it is worthwhile and beneficial for you to take the time to use that expense to do it right at the beginning, because if you try to do it yourself, the self-help way, you really just unravel a whole just lots of problems for your family, for sure.
Thank you for that. And then Teresa's got another question. So with the agreement for deed, is the title in the seller's name or the buyer's name, or once the property is completely paid off in 20 years or so, then the buyer's name is placed on the title?
Hopefully, yes, thank you for that question. You don't see agreements for deeds too much in Florida anymore. The one you saw was an older one. It's like your car. You don't get your title to your car until you pay it off. When you pay it off, you get your deed. The seller holds legal title, but the buyers, until they pay it off, have what we call equitable title. They have some rights. They have the right to be on the property and things like that. What I find very often happens, and it's in that case that I have, is the seller has passed away. And especially in this world where we do everything online, we may have direct deposits or automatic payments to pay off our mortgages and things like that. So nobody's looking at that. And at the end, in 20 years, like, okay, I've paid off my mortgage, and the seller's like, okay, we're done. They have to sign a deed, the warranty deed, over to the buyers. Then the buyer has legal title, and then they own the property. But often, like in my case, the seller has passed away. It was held in a company. the company is defunct. So what we'll probably end up doing is a quiet title action. It will be easy because it'll be default because there's no one to serve. But that's those agreement for deeds were used, especially out in the rural areas and years ago. We don't see them too much anymore, but you have to be careful and you have to try to find. And I think I had another one where the mortgage company didn't even think about it, gave a mortgage, like, but they didn't have property, they didn't have title. So don't trust a title company's work. Follow up.
All right, we've got plenty of other questions for you.
Okay.
So Caroline says the chart does not list the ladybird deed. Where does the ladybird deed fit into the chart? And I believe that's LaTonya's chart that she's on.
Yes, that chart, it was dealing with multiple grantees. So that's why I believe in that chart was tenants in common, tenants by the entirety, and right of survivorship. So that chart was really if you had multiple grantees, multiple people taking possession of the title. With the ladybird deed, it's not necessarily that you would have multiple people. It can be from one person having a life estate interest, giving it to one other person. So that's why I didn't include it.
All right, and I've got a question that I'll answer briefly. So Chioma, dear, she says, or they say that, or they ask if there will be a recording shared of this, and if there will be the CLE. So this has been recorded, and it will be posted on Community Legal Services of Mid-Florida's website or YouTube page. And the CLE information was posted in the chat, and it will be sent out in the follow-up email after this presentation. So I just briefly wanted to mention that. Next question is, what happens if renovations are needed on a property for a SHIP loan applicant? Does the applicant have to be the only or the sole owner applying, or all owners depending on the type of title that they have to the property?
That's going to be up to the cities that give the SHIP loans. That is one of the reasons that we try to get 100% interest to the person living in the property or to one person. Sometimes I've done this where I've coerced, I guess. We've used the ladybird deed as an estate planning tool for a couple of sisters who were concerned. We said, look, here's what we do. If you will give us a quitclaim deed to your sister who's living in the home, she's going to turn around and do a ladybird deed so that she owns the property and you get it when she dies. And they were fine with that. So she was able to get her loans or deal with her mortgage company. Otherwise, they're probably going to look at everybody who owns that property, and they will make a determination as to whether they will provide that SHIP loan or not.
All right, next question going in order once again. So Nicole Oriole asks, how does a reverse mortgage factor into this process?
Oh, don't do it.
Oh, I'm not a fan.
So reverse mortgages, we don't really deal with a bunch of them. We know we have some people over at Jacksonville Area Legal Aid who deal with those types of things. My understanding is that if there's a reverse mortgage, you can purchase the property back for 95% of the value of the home at that time. Doesn't have anything to do with how much is owed or anything on the mortgage, but it's 95% of the value of the home. We hope that people will talk to attorneys before they do a reverse mortgage. I understand why, but it's, again, you need to find who the heirs are and find out if everybody's interested in purchasing that home from the reverse mortgage company. If they're not going to do it, the mortgage company will file for foreclosure.
Mm-hmm. So in the circumstances that I have come across reverse mortgages, it is where it's time sensitive, right? They have come to us. They said that they are interested in, I guess, buying back the mortgage or so forth. And so they have a timetable and they need to get this probate done. And so we are then racing against the clock to go through the probate process to show that they have true ownership of the property in order to go through this process in order to purchase it. But that is the only circumstances that we really come across personally in dealing with how reverse mortgages come into effect after the person has died.
And most of our clients don't get reverse mortgages.
Which is good.
The homes there's not enough value in most of the homes to get a reverse mortgage.
And you're leaving such a huge financial burden on your family, and they, may or may not want to take that up. But yeah, good question.
All right, Patrick Hogan then asks, what would you suggest in circumstances of a quitclaim deed that is followed quickly by a warranty deed where it appears that the quitclaim deed may have been fraudulently created or executed? Would you quiet title action, or would you go through a quiet title action?
I'm going to do the law school answer. It depends.
It does.
What
does it say? That's my question. And I hate to ask a question, answering a question, but
right.
But what is the quitclaim deed saying? Is what you want to know. Is if what the quitclaim deed is saying is not fraudulent, and you follow it up with a warranty deed, there's nothing wrong with that. As long as the seller in the quitclaim deed actually has the interest that they are purporting to have, and they give it to the seller, and then it's followed by a warranty deed by the seller, and the seller is making these 5 covenants, these assurances that they actually possess it, and they do, there's nothing wrong with that.
Now, I can see where there may be some fraudulent, because I again, these come from experiences where a son signed a deed from himself as the power of having his father's power of attorney to himself. And then that deed also had some issues, but that they were cured by time. So, if he didn't have the power of attorney, and in this case, he had not, when you sign something as a power of attorney, when you record something, you are required, you're supposed to record the power of attorney to show that you had, and that had not been done. So I actually did do a quiet title action. There were a host of other problems, but I was able to get my client the title to the property, thankfully. But sometimes that's where you see, and that's exploitation, and that goes to those elder justice fellows.
And then Patrick also adds, suppose the quitclaim deed was not sold by a seller, but just a fraudulent signature.
Again, those are questions that I think are just way too deep for this presentation.
Well, I'm sure Patrick appreciates the answers that you provided thus far. I surely do. All right, so we've got 4 more minutes, and we'll try to fit in as many questions as we can in that time. I'll now go to Paul Flaunlacker. Hopefully
I'm looking at his question. I can answer that really quickly for you.
Perfect.
He's asking about tax liens, easements, code enforcement things. That's one of the reasons I go to the property appraiser's website first, pull up the property. In Duval, there is a link to the tax collector's office. So we can go look and see, are there tax certificates out there? How long have they been out there? We do all of that because we want to make sure we give good title to our clients. When they come in, we look at the title, we look at the taxes, we look at all of those things, because a lot of times, for instance, with the ship loans have language that if the owner stays on the property for 10 years or more, those ship loans go away. So they may not be making, their parents may not be making payments on that ship loan. So they have no clue that it's there until we do a title search and we're like, hey, by the way. And the SHIP loans do allow it to be the property to be inherited by family. And then that 10 years continues to tax so that the SHIP will disappear. So we try to find everything to let our clients know the status of their property so they can make an informed decision as to what they want to do and how they want to do it.
Okay, Mandy's question. Okay.
I'm really glad you pulled that one up.
Yeah, okay.
A long one.
Can I go ahead and read it? Let's see, I have a person who has an agreement for deed that they fully paid, where we're at the point of getting a deed from the seller. The property appraiser lists the owner as person X and YAD, where the person is the buyer, my client, and the AD indicates the agreement for deed. My client buyer has been getting the homestead exemption since the 80s. When the deed from seller to buyer gets recorded, do they think they will lose the benefit of the cap on the property tax increases, or will their property taxes now be based on the value of the property today when the deed is recorded, since there is a conveyance of legal title?
What I'm finding with these agreement for deeds, which is the problem of the property appraisers recognize the buyer as the owner because they're living on the property. The problem comes when that deed has not been recorded. So they're going to continue to get the homestead exemption. They've already told, because the property appraiser recognizes the agreement for deed. They have that equitable title, so that property appraiser is giving them the homestead exemption. Now, as far as the value of the properties, that's always changing anyway. I mean, that's why you get your trim notices every year. It says, you know, here's what the value is going to be. Here's what your taxes are going to be. So I can't answer a question for the property appraisers, but what I've seen, which is why, again, we don't trust the property appraisers website. We go and pull those deeds and read those deeds and make sure if maybe that the seller did record something under somebody else's name or something, somebody else signed a deed for the grantor, the seller. But it doesn't look like a problem, but they have their property and they've got to have that deed. Until they have that deed, they do not own that property. And technically the seller could go and sell it to someone else outright.
It's a presumptive interest, yeah.
Right.
Mm-hmm.
And that's just going to create a problem for your client because they're going to want to sue on contract, not in real estate, but on contract laws.
Yeah. I think we hit all the questions, Brianna. Did we?
I think so, and we are right on time.
Wonderful.
Thank you so much. Thank you everyone for being here. Thank you so much, LaTonya and Rachel. I really, really appreciate it. This was wonderful.
Pleasure.
We have a lot of thanks and compliments for your presentation in the chat. So I hope you get a chance to look at those. But thank you so much. I just want to mention one more time that I've placed our pro bono coordinator, one of our pro bono coordinators, contact information in the chat. So if you would like to volunteer with CLSMF, you're welcome to email Japonica Jackson. And then if you would like to volunteer with Three Rivers Legal Services and their pro bono unit, feel free to contact LaTonya or Rachel as they will guide you in the right direction. I have also put the link in for the CLSMF's pro bono annual virtual walk-in clinic. And that again is October 27th. And that'll be next week from 3 p.m. to 7 p.m. And so if you would like to volunteer with that event, that link is also in the chat. So click on that link and it'll take you to the form where you can sign up. And then finally, the CLE code is, I placed it in the chat multiple times. It'll also be emailed to you after this presentation. And then finally, this presentation was recorded and will be placed on CLSMF's or Community Legal Services of Mid-Florida's YouTube page.